Before we get started, we just wanted to thank Old Republic Surety for sponsoring this episode of Let's Get Surety, as well as NASBP's virtual seminars for the third year in a row. For more information on Old Republic Surety, visit www.orsurety.com. Now, on to our show.
You're listening to Let's Get Surety. Let me hear your bonding talk with Kat Shamapande.
Hey everyone, it's Kat Shamapande, and welcome to this episode of Let's Get Surety. So today we're going to be talking about the False Claims Act. I've got my co-host, Mark McCallum, CEO of NASBP. Hey, Mark.
Hey, Kat. How are you?
I'm good. I'm glad to have you on with me to talk about this.
Yeah, we're talking about a topic that won't seem to go away, even though we wish it would.
Oh, man.
Right?
Yeah, it's good we have two guests who are well-versed in this area. We've got Alba and Matt Feinberg, partners with PilieroMazza PLLC. Hey, hey, Matt. Thanks for being on with us today.
Yeah, thanks for having us.
Yeah. Hey, Kat, how you doing?
Great. Well, before we kind of dive into the False Claims Act, can you guys tell us a little bit about yourselves and about your firm?
Sure, I can. Hey, this is Alba. I'm a partner with law firm of PilieroMazza. PilieroMazza has been around for a while now, 30 some odd years, I think, mainly representing federal contractors in all number of manners, and more recently kind of expanded out into, we have labor and employment, Matt's in our litigation group, we have M&A, sort of business and transactions, and then our standard or sort of core GovCon practice as well, which we've had for many years, and I'm in the GovCon group.
And this is Matt Feinberg. Like Sai said, I'm a partner in our litigation and dispute resolution practice group. And both Sai and I are also on the firm's False Claims Act and Audits and Investigations team. So we do a lot of False Claims Act work, including in the construction industry and with sureties. Hopefully today we'll be able to give you a couple of war stories, but also give your listeners the lay of the land and where things are and maybe where things are going in the next few months and few years.
That sounds great. So to kick us off, we should probably just start by talking about what is the False Claims Act and how does it work?
Sure. So the False Claims Act is the primary vehicle that the federal government uses to collect money that has been paid out or that is owed to the government as a result of a fraud. Now, these are some hot buzzwords: fraud, fraudulent intent, things like that. But what we're really talking about is a government contractor or a company affiliated or touching a government contractor that is making a request for money from the government, usually the submission of an invoice or a claim, which is usually a change in the amount of a contract, something like that. Or it's a company trying to avoid a debt to the government. So that's particularly relevant to us today in the context of a surety and a False Claims Act claim, where it is a surety attempting to avoid an obligation to pay out on a bonding claim to the government, something like that. Now, obviously, not every single attempt to recover money from the government or keep money that the government has paid is a false claim. What we're talking about is intentional or reckless misrepresentations to the government. And a reckless, intentional, pretty obvious. You intended, you had the specific design to obtain money or avoid a debt to the government. A reckless attempt or a reckless intent would include what sometimes we're referring to as the ostrich principle, sort of sticking your head in the sand when there's fraud going on around you and not doing something about it, or continuing to affiliate yourselves with these alleged nefarious actors. Ultimately, the False Claims Act is a very significant bat that the government wields, right? Because there are not only the ability to recover treble damages, 3 times the amount of the actual damages that the government has allegedly suffered, but there's also a penalty provision in the False Claims Act. And so for every claim that is made to the government, whether that be a single invoice on a construction contract, or it could be every single invoice submitted on a government contract, there's a penalty of anywhere between about $11,500 and $23,500 that can be assessed per invoice. So it's a very significant potential liability and a heavy bat that the government swings at construction companies, at sureties, and at other government contractors who are participating in the construction industry.
Wow, that sounds pretty scary, Matt. Is there just a civil side to the statute, or is there a criminal side?
So that's a great question. Most often we deal with the civil side because for those of you who know, the criminal side requires a higher standard of proof, right? Proof beyond a reasonable doubt.
Right.
So in order for the government to bring criminal action against a False Claims Act defendant, the government has to have this slam dunk, obvious, maybe a smoking gun document somewhere, or sometimes they'll have, let's say in a prime contractor, subcontractor relationship, one of them has flipped on the other. And that's when they'll usually, and I shouldn't even say usually, they're more likely to bring criminal charges. On the civil side, we're talking about a lower standard of proof. It's not preponderance of the evidence, but it is less than beyond a reasonable doubt. So there is a criminal component, there is a civil component, and you're far more likely to see the civil component for a False Claims Act claim, at least these days.
Okay. Sai, I thought either you or Matt had mentioned that, contractors can be in the line of sight and perhaps even sureties. Can you tell me a little bit how far the reach is of the statute? Is it only those in privity with the government, or can it be others?
Yeah. So when you're talking about the contractors, and then I'll let Matt touch on the sureties in a minute, but when you're talking about the contractors themselves, I've actually had cases where we represented a company who had never done a federal contract ever as a prime or as a sub. Never. Okay. And that company had provided a loan to someone who allegedly, like, they were romantic. The owners of the two companies were romantically involved. The owner of the one company, who had zero federal work, gave a loan to the owner of the other company in order to help her get started. She claimed woman-owned status, got a subcontract to a larger prime contractor. That status, the government alleged, was not appropriate because they said there was affiliation between the two companies and things like that. And the government came after the prime, the sub, the woman-owned small business, and our client at the time, because they said they were all in conspiracy to violate the law. So it depends on how that's kind of the most aggressive I've ever seen it. But that just is a good example, I think, of how they could try to tie everything together if they wanted to.
Wow. That kind of reach, it certainly seems like they could put sureties in their line of sight, that is, the government or the Justice Department. Would you agree with that?
Oh, for sure. And I think it's important to talk about how a False Claims Act claim starts a little bit. So there's two primary ways. The first is a government-initiated claim. Typically, that's a claim that maybe comes in on a hotline to the Office of Inspector General. The Office of Inspector General then refers it out to the appropriate attorney or division to investigate. But the second is the way that a lot of times the surety or these sort of borderline players in the fact pattern get pulled in, and that's by what's called a QTAM relator. And that is a whistleblower. Okay. It's either a former employee, a current employee. Sometimes it's a competitor. It could be an independent contractor, someone who has a little bit of inside knowledge about how your company runs, who is able to file under seal what's called a QTAM complaint. And it is essentially a False Claims Act claim that is made in the name of the government, but filed by this whistleblower. And then it is immediately sent to the government for investigation. And the government has to make a decision whether to intervene in the litigation that has been filed or to decline to intervene. And if the government intervenes, it takes over the investigation completely. If they decline to intervene, then the key tam relator and their attorney have to handle it by themselves. So one of the main motivators for the relator when they file these lawsuits is that they get a percentage of the recovery. Usually somewhere between 15 and 25%, but it can at times go up to 30%. And so when we're talking about a construction contract, let's say a $20 million construction contract, if that entire contract was procured by alleged fraud, the False Claims Act can treble those damages or the entire contract value, gets us to $60 million. Plus, maybe they submitted 100 invoices over the course of that, or applications for payment over the course of that contract, and you've got 23,000 times 100. It's very quickly adding up, and the relator wants a bite at that recovery, and so their strategy is to name as many people as they can with the deepest pockets. Who's got the deep pockets?
Wow.
The surety, another insurance company that might be involved, the larger company, maybe a large company subcontractor that's assisting a small business with a construction contract. So there's a lot of motivation on one side to bring in as many people and get them all to the table in order to boost the amount of money that's a potential settlement of that claim. And that's where you often see sureties coming in and other sort of fringe participants in the central alleged fraud. And the farther away you can get from the central alleged fraud, the less likely you are, or I say the more likely you are to get away from the case. But the closer you are, if you're the surety company that is bonding out a construction project these days,
Right.
There's likely to be some sort of allegation in a construction contract, simply because that's the hot topic. It's succeeded. Naming sureties in these types of cases has succeeded a couple of times, at least at the motion to dismiss level, and so this is the trend in the industry now.
I see. So the government is going to bring everybody that they think that has some relationship into the suit. I have perhaps an interesting question for you. The key tam relator, can they actually be involved in, quote, the behavior that gives rise to the claim and then try to recover for their own pocketbook as a key tam relator?
So technically, no. If they are the person at the company charged with the activity. So for instance, if it's, let's say there's a claim over false certifications of participation in one of the SBA's small business programs, let's say Hub Zone program. If the key tam relator is the person charged at the company with maintaining compliance with the Hub Zone program, no, that person is not going to be able to serve as a relator. But the reality is that person probably filed their suit anyway, and the government is still investigating. And at the end of the day, the government still needs to make the decision of whether to intervene or not intervene. And so if the problem exists, the government probably takes that case on their own, and there is no key tam relator left in the case to receive part of the recovery. But what they've said, they become a chief witness for the government, right? And so suddenly the government is sort of advocating the original key tam relator's points.
And another just thing is when you're talking about these relators, I'll give you a couple examples too that are a little outside of the scope of what you would think of. One was individuals who had been in a relationship, they were married for many years, and the guy who I knew had a company, 8A company. They weren't exactly following the rules. I was talking to him about that because his wife had filed for divorce and had raised the issues as part of the divorce proceeding as, leverage essentially. I don't think anything ever came of that. but it was not a good situation. I think they settled the divorce proceeding, but there was a lot of leverage there. It's not necessarily appropriate for a lawyer to necessarily threaten that kind of thing, but I guess the client, and so that is one example. Another example was one where, and this was the last case we actually settled, FCA case that we settled, was an individual who was working for the prime contractor, went to then work for the subcontractor. A couple weeks after the person started with the subcontractor, it was discovered that the individual had been embezzling money from the prime before they had left, to the tune of about $250,000. That person then, the prime pressed charges, the subcontractor filed them, prime pressed charges. The individual was convicted and went to prison. And the way they told the story, I'm not sure this is true, but like as the guy's getting, hauled off in handcuffs, he's like looking at the other side and be like, I'm going to get you type thing. Oh. Guy got out of prison, filed a False Claim Act case. This was in 2012. The guy filed it. Matt said, it's under seal. We found out about it in like 2014 or something like that. So it was 2 years later. We finally settled the case in like 2017. So it was like 5 years later. And it was just a mess. And the guy basically got enough money out of that to fulfill his obligations under the restitution order to pay back the prime contractor. So the prime basically paid themselves back.
Oh my gosh.
When truth is stranger than fiction, right?
Right.
Wow. Well, I wanted to kind of go back on something you alluded to earlier, about the idea of you're essentially seeking payment from the government. And I know contractors make a lot of different representations to get, as part of the payment process. Maybe, Matt, you could characterize some of the incidents where you see potential false claim liability arising in that kind of, acts or behaviors.
Sure. So in the construction industry in particular, there are a lot of ways that the False Claims Act can be implicated. And I'll let Cy talk about a few of them as well. But when you're a small business, you've received your construction contract as a result of participation in one of the SBA's, Small Business Administration's, small business programs, set-aside programs, the entire contract is an implied certification that you meet the obligations of that set-aside program. There is an implied warranty that the products and services you are using are compliant with federal law, the obligations of your contract, and that are fit for a particular purpose. The example that is not construction that I have always given is a pretty famous case where a thread manufacturer sold thread to a bulletproof vest manufacturer for the military, and the thread was faulty. And both the thread manufacturer and the bulletproof vest manufacturer ended up being, well, I think they ended up settling, but they ended up with a False Claims Act case against them because they were providing a faulty product into the marketplace. In construction in particular, you could violate the Davis-Bacon Act, which, as many people know, requires you to certify your payrolls on a weekly basis. That individuals who are working on the project worked a certain number of hours, that they meet a certain job classification, let's say sheet metal mechanic, and that they are being paid the appropriate amount of prevailing wage for a sheet metal mechanic in the industry in the location where the work is being performed. So in particular, construction companies have to worry about the Davis-Bacon Act constantly. It applies to any contract. I'm going to loosely call it construction. There's a little more than that, but any construction contract valued at more than $2,000 of receiving $2,000 or more of federal funds. So what construction project is less than that, right? So it's a constant concern. And then you also go ahead.
So, Hey, Matt, I was just curious. So for that type of certification, is that only a concern by the prime contractor, or does it flow further down?
So it flows to the company that is actually certifying the payroll. So if it is a second tier subcontractor that is providing, let's say, the drywall installers, they must provide, that second tier subcontractor must provide the certified payrolls to its first tier subcontractor. The first tier subcontractor must pass those up to the prime contractor. So in an instance like that, if the underlying misrepresentation in a Davis-Bacon Act context is made by the second tier subcontractor, you could potentially flow False Claims Act liability all the way up to the prime from the second tier sub. Now, if it's the prime that's making the representation, it doesn't flow down. So the first tier subcontractor and the second tier subcontractor would likely not be on the hook unless they're participating in the misrepresentation. But generally speaking, it will flow up because ultimately it's the prime contractor that has the obligation to the government.
Right. Wow. I imagine change orders could be a potential area for, liability in this regard. Is that something, Si, that you've seen?
Yeah, especially if going to that reckless standard. Very rarely do you see a situation where it's willful or they do it with knowledge that they're doing something wrong. But you'll see it where there's some evidence or someone inside the prime contractor questions or should have reason to question whether or not the invoices are accurate or there's some issue with them. If there's overbilling or if they should know that something looks higher than it otherwise would be, especially when you're talking about cost reimbursable. And in that context, I've seen change orders submitted. If they're, it used to be called TINA, the Truth in Negotiations Act. They keep changing the names on all these. I still call it TINA. But you have like the Truth in Negotiations Act, where if there's something that isn't competed, right, and it's over a certain threshold, it used to be 7, now it's up to 2 million because of the COVID stuff, that if there's a change order that's that large, then you're supposed to be checking cost and pricing data. And so that's another area where I've seen prime contractors fail to do that. They fail to check the cost and pricing data or secure it. Or if they looked at it, they haven't, and there were some red flags in there, they haven't pushed back on the contractor. So those are sort of nexuses where something could occur in the FCA context. And that's where you would get everybody in the line. Whereas a situation, meaning both the prime and the sub, in a situation, though, where I also had where a subcontractor completely falsified something and there was no indication that it was false or sort of an observer couldn't tell, it's less likely in that case that the prime is going to actually get caught up in that scenario. I had a construction contract in Afghanistan, and part of the contract was shipping in supplies through Pakistan. And this was a few years ago when the border closed for a while. And when the border closed, all these goods and services got stopped and all the supplies were stacking up. And because they were out of containers for everything, the prices were going up. Well, this subcontractor had secured a good contract to keep the prices low. But because the prices were increasing, they saw an opportunity to make additional profit. They, even though it was supposed to be a fixed contract, they increased the prices because there was a clause in the subcontract that could allow it in certain circumstances. They falsified those circumstances and it wasn't obvious on its face. In that particular instance, the government went after the subcontractor and not the prime. We were dealing with the prime contractor in that case. And we were working essentially with the government and cooperating with the government, withholding payments to the subcontractor, things like that. And at the end of the day, nothing happened to the prime contractor. It was more assisting with the investigation of the sub. So that's where it comes down to how much did you know or how much should you have known, to that like ostrich rule.
Right. Earlier, Matt, you talked about a small business and running afoul of the False Claims Act. And obviously, there are a lot of socioeconomic programs with the federal government. So, would that be true of any of those, like women owned or veteran disabled? Do they also pose threats if the accuracy of that is in question?
Yes, but they absolutely do, and it brings up a sort of a tangential issue as well. But yes, so if a company is awarded a contract on the premise that they are a hub zone company, or and for those who don't know what that is, a historically underutilized business zone company, it's generally a company that employs employees in certain under commercialized areas of the country. Woman-owned small business, service disabled, veteran-owned small business. If a company receives the contract as a result of its participation in that set-aside program, then there is either an express or implied certification that company was eligible for that contract at the time of the bid, at the time of the award, and in some cases during the entirety of the performance. And so if, for instance, a small business company takes over a construction contract and subs a significant portion of the work to a large business, one that wouldn't be eligible for the contract, they could run afoul not only of the ownership and control requirements that are with those set-aside programs. There are a number of factors that go into whether that company is truly eligible for that set-aside program. But it could also run afoul of the limitations on subcontracting requirements that are inherent in those programs. In most construction industry cases, there's a 15% requirement where the prime contractor has to perform 15% of the labor costs.
Right.
And if so, that's another way. If the prime contractor isn't quite ready for the job or isn't able to control the subcontractor well enough to limit the subcontracting work that's performed, that could be another False Claims Act violation. And that's actually, Cy and I have seen a huge uptick in the government's focus on the limitations of subcontracting, particularly in the construction industry. They are initiating a lot of investigations and pursuing a lot of False Claims Act allegations against construction contractors that are some that are meeting their obligations on the limitation of subcontracting, but there's a question somewhere along the way, or companies that just are close but aren't meeting those limitations on subcontracting requirements.
Wow. I imagine then for particularly status and areas like that, that the surety may be looked at by the government as part of assuring that status is in fact correct by virtue of providing the bond. Are you seeing anything like that?
A little bit. So right now there are two major cases where sureties are involved in fairly well-known litigation under the False Claims Act. And one of those cases is called Skolic. It's pending in the District of Columbia right now, federal court. And just for the disclaimer, my firm used to be involved sort of tangentially in that case. But I won't be providing any of the insider details, but I'll give you the lay of the land. Essentially, in that case, the principal, the prime contractor for that contract was certified as self-certified as a service-disabled veteran-owned small business. And at some point during the initial stages of the contract, or possibly right before, the surety did an on-site evaluation and investigation of the SDVOSB company to determine its bondworthiness. And at the time, it is alleged, and I want to preface this by saying all of this is alleged. None of these facts have been established conclusively.
Right.
Other than the fact that the surety did do the on-site investigation. The government and the relator in that case alleged that it should have been obvious to the surety at the time that the prime contractor was a shell company and could not have been a service-disabled veteran-owned small business. And so the sheer fact that the surety bonded out the contract for the alleged shell company. That was enough for the surety to be drawn into the False Claims Act case, because essentially what the government was saying and what the relator was saying is that every single time that any work was performed on the contract by the shell company, they were breaching their government contract. And the surety theoretically should have been on the hook for every single breach by the principal. Therefore, the government or the bonding company continuing to bond the project was essentially an effort to avoid paying the government for the underlying bond that should have been owed for every breach. Now, those of you who are listening to me are probably saying, this seems crazy. That's not how bonding works. The bonding company is not responsible immediately for every breach of the contract. And you're absolutely right. Mm-hmm. The reason that this is the law right now, and it is not controlling anywhere except in this specific case, is because we don't have a final decision. The bonding company, the surety in that case, filed a motion to dismiss, said, wait a minute, we are under no obligation to intervene in another entity's violation of the FCA and stop them or report them. This is not the final episode of Seinfeld. Like, this is not our fault. And that's correct. There's case law that says a company is not required to intervene. However, the standard on a motion to dismiss, which is where that case was at the time, is that you take the facts in the light most favorable to the non-moving party. That's the government and the relator in this case. And so the court said, is there a possible way that the jury could find at trial in the plaintiff's favor? Yes. So I'm not going to dismiss this case. That case has been going on for years. Those motions to dismiss were filed in 2017. It's now 2021, and and that case has summary judgment motions pending. Do I think that there's a significant chance of liability for the surety in that case? I personally don't. But it remains to be seen. Hopefully we'll see some summary judgment decisions coming out over the next few months. And at that point we'll have a clearer picture, but that's where we are right now. There's this theoretical possibility that a surety, by not taking affirmative steps to notify the government of a fraud or decline to bond out a job because there may be underlying fraud. That's where we are right now. It's possible that the surety could be liable under the False Claims Act for those actions.
And I imagine that they're not just looking at the surety's actions or behavior, but also the bonding agent. Is that correct?
So in that instance, I believe that the brokers were dismissed because... One, they don't actually issue the bond themselves. So they're not physically or financially on the hook for anything, and they're not in privity officially with the principal. So I'm fairly confident that all of the brokers were dismissed from that litigation and that no one tried to pursue them again.
But they were brought in originally. Is that correct?
Were brought in originally. Now, this is one of those instances where you've got a Ketam relator, whose name is Skolik, who brought in a significant number of parties, trying to attach liability threads to as many people as possible. And inevitably, in those circumstances, some of those threads are going to be cut, and the parties are going to be dismissed. But in this case stands out a little bit because there are so many parties still actively defending that case.
Right. And listening to these examples, it sounds like there's additional risk incurred by producers and sureties when they're supporting federal contractors. Is that the right way to look at this?
Sure. Yes. Unfortunately, there is I would say, a little bit extra risk. I don't think that any sureties, any representatives of sureties should really lose sleep over the possibility that a False Claims Act case could land on their doorstep, tomorrow. But and certainly they shouldn't stop bonding federal jobs, because
Right.
that would be an insane result from a couple of examples. I think what the surety really needs to be looking at is, have we done our due diligence in issuing this bond? And knowing the types of issues that can come up, thinking a little bit outside the box and trying to look at bonding from the perspective of an outsider, not necessarily just from inside the industry, could potentially help clear up some of these issues. And then documenting your investigation, your internal due diligence, those are all ways to mitigate that risk. But the strict answer to your question is, yeah, probably there's a little bit of extra risk bonding out federal contracts, simply because there are more avenues for liability, and really the boundaries of a False Claims Act claim are the imagination of the relator or the assistant U.S. attorney who happens to be charging or filing charging the criminal complaint or filing the civil claim. Cy and I have been on some cases before where, in particular, I have one right now where I just don't understand what the government's position is, because it's just not correct. But there's a lawyer out there who thinks it is correct, and that's why they're proceeding on it. So, we'll continue to defend it, but there is that risk. And the boundaries of the False Claims Act continue to be pushed in every direction. And so, yeah, there's some risk, but nothing to worry about at this point. I'll be interested to see what happens in the Skolek case, to see if there are some extra protections that are going to be baked into the law for sureties in particular, because I think the surety has a very good argument in that case.
Well, Cy, in the meantime, I know Matt was mentioning doing due diligence and documentation by the surety and the bonding agent and so forth. What other steps or what other things should those parties be thinking about to avoid, any allegations of False Claims Act behavior?
So I think in particular, if you're talking about small firms, and small is somewhat relative. I think you can have like 30-something million a year. And then for certain NAICS codes that are employee based, they could actually be pretty large companies financially. So, but if you're bonding someone who's bidding on that kind of work, I think understanding what some of the rules are and what some of the key issues are depending on the program. So, for instance, if it's a VA job, the Department of Veterans Affairs, right now, and maybe in a year or two, these rules might change because SBA is taking over the program. But for right now, the way it works is you have to be in CVE, which is the database that the VA uses to verify veteran-owned companies. You have to be in that database both at time of bid and at time of award. Whereas most other scenarios, in fact, SBA just changed HubZone to make it so that it's like all the other programs. Outside of the VA, it's only time of bid. So if someone is a HubZone or a woman-owned or whatever, not in the VA at time of bid, and they're qualified for the rest of the contract. So whatever happens, if they submit on December 31st and on January 1st, because that's their calendar year, they're now a large business. Because they submitted on December 31st, they're still small, they're fine, they're good to go for the life of that contract. But knowing that for the VA, it's also at time of bid, you have to realize that if they submitted on December 31st, they became a large business on the 1st, this award happened February 1st, that company, let's say they say, oh, well, we're still fine. Yeah, we're a small business. Look, it's when we certified. That could be a false claim because that company knew or should have known about their scenario. So that's sort of an example of these areas. Also, if you're looking at like a teaming agreement for a prime contractor, again, who's a small business, and the teaming agreement shows that they're not going to do the work correctly. They're going to subcontract out 90% of the work, right? Like Matt was saying, it's supposed to be 15% self-performance. That's a problem. Understanding how you get that number. It's now total cost of the contract for construction. It's total cost of the contract minus materials. So you have to take what you expect the entire contract to be. Let's say it's $1 million, or let's say it's 1.2, and then 200,000 is materials. You throw that out. You look at the 1 million that's left. 150,000 of that 1 million has to be done by the prime. Like, just understanding that. So if there's something clear on the face of the documents you're looking at, you can take a step back and say, wait a minute, guys, something doesn't look right. Because that's where they're going to get you on a reckless standard. Another thing I think I would note too is more and more companies are forming joint ventures because of the way these procurements are coming out and allowing you to use experience, past performance, all that stuff. For construction, joint ventures are more difficult to do correctly than for standard services work. And that's because the JV rules, when SBA put them in place, were supposed to be beneficial, because they said, hey, if you're in, let's say you're in a mentor-protege joint venture, which is a program where SBA certifies a potentially large business to be a mentor and to support and help a small business protege. Under the rules, they're allowed to form a joint venture. Usually a small couldn't form a joint venture with a large and still be eligible. But if you're a mentor and a mentor protege, you could be a large business in a joint venture. So let's say you form that. For services, if you were prime sub, the mentor could only do 50% of the work. But if you form a joint venture, the mentor can do 60% of the work. Out of whatever, that's out of the work that the JV is doing. So if it's $1 million contract, the two members of the JV have to do at least 500,000 combined, because that's the 50% that they have to do. Out of that 50%, the small business has to do 40%. So 40% of the 50, and the mentor can do 60% of the 50, which is more than 50% of the 50, which they would have to do if you were outside of a JV. Now, the good thing about that for services is the mentor can do more work. But if you're in construction, it's split out of whatever work the companies are doing. So the JV, instead of that 50%, has to do at least 15%. And then the mentor can do 60% of that 15, or whatever amount you're doing. What we see over and over is where people don't understand that 60-40 split is a 60-40 split of whatever the members combined are doing. And what people do is they say, well, we're in a joint venture. I, the mentor or the non-qualified party, I'm going to do 85%, including all the subcontractors that are under me, and you do 15%. But what happens there is that's all inside the JV, and that's supposed to be split 40-60 at least 40 going to the protege or to the qualified entity. And if you're doing 85, it's not 60-40, right? That's 15-85. And that's a problem. And that I'm seeing that come up more and more, where people don't realize they're creating joint ventures, they're bidding as joint ventures, but they're not using the right rules. And so you need to pay attention. In construction in particular, it's not automatic that a JV is going to be better or easier to work with. It could just be a trap, an FCA trap. So you might want to just do prime sub, because if you do prime sub, the prime does 15, you do 85, you're fine.
Right. Well, Matt and Sai, I think you've made a strong case for knowing a knowledgeable attorney and asking questions before you submit documentation to the government. So I think that's going to be one of the important takeaways.
For
today.
sure.
So,
And if I could just piggyback on what Sai said a little bit. So I was talking about due diligence. Everything that Sai said to the average person is going to be super confusing. You know, people are going to be rewinding this podcast to listen to that and take notes 3 or 4 times. It's confusing for everybody, including the government, including the person who's investigating. It's including the relator that might file a claim. And so really having a paper trail to explain why the breakdown was what it was, ideally exchanging that with a lawyer to make sure that it's okay. and to protect it from discovery should the lawyer need to tell you, nope, this is wrong. We've got to fix a couple of things here and there, make some tweaks. You'll be fine if we do that. It's really important to have that paper trail and exchange it with a lawyer so that you know what's going on basically throughout the entire contract. Because what happens if you're performing this construction contract and 3 months from finish, you realize you've been doing it wrong the entire time? Now, you may have those 3 months to get it fixed, but what happens if in order to fix it, the small business prime contractor suddenly has to do 65 or 70% of the work over the last 3 months? That may not be something that's feasible. And so it may not be a fixable problem in practice. So understanding early what your obligations are, making sure that you're following along and doing periodic checks to make sure you're compliant with those performance of work requirements, super important in the construction industry.
Great advice. Great information.
And really, another thing too, I would just say consultants are great, but I've seen more and more consultants come into the GovCon space, and they can be really helpful for certain issues. But if you have a problem like what we're talking about and you think there's an issue, do not call consultant XYZ and like spill your guts to them, because that's all discoverable, right? If there's any even hint of an issue, you want to make sure you're talking to a lawyer to get an opinion on that, not a consultant. So make sure.
You get that good attorney-client privilege, right?
Well, I just wanted to thank you both, Matt and Sai. Is there anything else that you want to provide as a key takeaway? I mean, I think we all got that you need to speak with an informed lawyer. But is there any other key takeaway you want to give to the audience around the False Claims Act violations and mitigating those risks?
Sure. I think that one of the key takeaways for me, particularly for sureties, is do your due diligence, but do it in a way that is practical for your company. I'm not asking you to learn the 12 or however many factors it takes to determine whether a company is a proper 8A or a proper STVOSB. But it doesn't help to ask the right questions and make sure that if you're bonding out a job, you do that site visit, that you ask, let me know who's the controlling entity of this company. And if what's happening is that you're not speaking to that person at all, then maybe there is a red flag there about whether this is an STVOSB that's actually controlled by a service-disabled veteran. The Skolik case is sort of a red flag for me because the surety didn't have an obligation to investigate whether that company was a proper STVOSB. The insurer didn't have an obligation to report to the government that there may be a False Claims Act violation. Even if the surety thought that one was happening, which I kind of doubt the surety thought at the time. But by bonding out the contract, they have sort of drawn themselves within that web of potential FCA liability, and not having the documentation and the communications with counsel to potentially show the government early in the case that they have done their due diligence. That's a potential risk, I should say. So I would say the key takeaway for me is having that documentary paper trail where if something happens down the road, and a lot of companies can't avoid it because the key TAM relator is not always going to have the whole story. They're going to file these False Claims Act cases regardless of whether there's really a case there or not. But having that paper trail can save a lot of money, time, and distraction for the company down the road.
Great. Well, thank you guys both so much for coming on and just talking through the False Claims Act and the risks associated with it with us. We'll have to have you guys back on another podcast sometime soon. It was great chatting with you.
Thanks so much.
It sounds good to me. Thank you, guys.
Thanks, Matt. Thanks, Sai.
You've been listening to Let's Get Surety, brought to you by the National Association of Surety Bond Producers. For more information about the NASBP and its members, Visit NASBP.org.
Before we go, we just wanted to say thank you again to Old Republic Surety for their generous support in sponsoring this episode of Let's Get Surety. For more information on Old Republic Surety, visit www.orsurety.com.